Furthermore, the shorter period of leave deprives communishing parents of the opportunity to structure their parental responsibilities according to their personal circumstances, thereby intruding upon their private life, thereby undermining their dignity. There are several reasons why certain couples opt for adoption or surrogacy. They should not be penalized for this. There are also many reasons why partners decide that the father should be the primary caregiver. The case of the Van Wyks has shown that even in instances where the other partner is a birth mother, circumstances may dictate that the father assumes the role of primary caregiver. Legislation that prevents them, without any legitimate reason, from arranging their affairs according to their personal circumstances and preferences, intrudes upon their private space unnecessarily and impacts their human dignity. Regarding the issue of an age gap for adoption cases, the right that is limited here is the right of adopting parents who adopt children who are 2 years or older, and the right of the adopted children themselves. The extent of the limitation is that the parents are not afforded an opportunity to be at home, away from the workplace for the same period as other categories of parents, and that their adopted children are not afforded the opportunity to be with their adoptive parents after adoption. As stated above, I accept that the primary focus of granting leave after a family has acquired a child, either through birth or other means, is nurturing. However, an adjustment to a new environment is also very important, and although it is not the primary focus of the legislation, it cannot be excluded. The extent of the limitation is such that there is no leave at all for adoptive parents with adopted children who are 2 years or older. This court finds that adoptive parents of children who are older than 2 years and their children are treated differently from parents and children younger than 2 years. It is not clear what a reasonable cap should be. This is a matter best left for final determination by the legislature. As the unfair discrimination cannot be justified, an order that the capping of the age at 2 years is unconstitutional must therefore follow. Lastly, in respect to the remedying of the corresponding UIF provisions, I find it inappropriate for this court to provide an interim reading in that has an effect before the suspension period lapses, as the UIF Act is regulated differently from the BCEA. This court does not have sufficient information at its disposal regarding how the benefits in the corresponding provisions of the UIF are calculated. Given that a reading in respect of the impugned provisions of the UIF Act is more complex than in the case of the BCAA, it seems preferable to defer the question of such a reading in. The order shall thus include a direction that this question be timeously brought to the court's notice for supplementary relief. In the event of it appearing likely that there will be a need for a reading in remedy. The same will apply to the 2-year gap, 2-year age cap in section 25 capital B1 of the BCEA. Having held that sections 25, 25 capital A, 25 capital B, and 25 capital C of the BCEA and the corresponding sections of the UIF Act are inconsistent with the Constitution, it is appropriate for this court to make an order affording Parliament an opportunity to cure the defects. In the result, the following order is made. 1. The Commission for Gender Equality is granted leave to appeal against the High Court's decision not to declare as invalid and inconsistent with the Constitution the age limit of 2 years in respect of Section 25 capital B1 of the BCEA and Section 27(1)(c) of the UIF Act. 2. The declaration made by the High Court that Section 25 capital A, 25 capital B, and 25 capital C of the BCEA Act dealing with maternity and parental leave, together with the corresponding sections 24, 26 capital A, 27 and 29 capital A of the UIF Act, are invalid and inconsistent with the Constitution to the extent that they unfairly discriminate between different classes of parents as to the length of parental leave available to parents and as to the unemployment benefits to which they are entitled, and the periods for which unemployment benefits are paid is confirmed. 3, it is declared that Section 25 capital B1 of the BCEA and Section 27(1)(c) of the UIF Act are invalid and inconsistent with the Constitution to the extent that they limit parental leave and related leaves and related benefits to the case where the adopted child is below the age of 2 years. The declarations of constitutional invalidity referred to in paragraphs 2 and 3 are suspended for a period of 36 months from the date of this order to afford Parliament an opportunity to remedy the constitutional defects giving rise to the constitutional invalidity. 5, pending the coming into force of any remedial legislation as contemplated in paragraph 4, the impugned provisions of the BCEA shall contain a reading in which has the following effect. I pause here and clarify that I'm not going to read the order containing the reading in, but what I'm going to do for these purposes is to highlight the effects of the reading in. But parties will have to see from the whole order what it entails. A, the current leave of 4 months for biological mothers should be retained. Leave should not be restricted to mothers, but should extend to fathers as well. Where only one of the parents is employed, such parent should be entitled to the full parental leave. In the case of a biological birth, the mother must have preference in respect of the time currently allocated as preparation for and recovery from birth. Subject to this qualification, the parents should be entitled to share the available days as they choose. In the event of disagreement, the leave contemplated in the relevant section shall be apportioned between the parents in such a way that each parent's total parental leave is as close as possible to half of 4 months and 10 days. There should be a requirement that a father who wishes to avail himself for paternity leave qualifies as one who has assumed parental rights and responsibilities over the child as contemplated in the Children's Act. The additional 10 days contemplated in Section 25 capital A, which related to paternity leave, should also be allowed, giving a total of 4 months and 10 days leave to be shared between the parents. B, parental leave, which now combines the former maternity and parental leave, and paternity leave rather. Adoption leave and commissioning parental leave will equally entitle parents to 4 months and 10 days shared leave. Accordingly, Section 25 capital A of the BCEA shall be deleted. 6, not later than 6 months before the expiry of the 36-month suspension period, the minister must furnish a report to the registrar on notice to the parties as to whether remedial legislation in respect of the BCEA and UIF Act has been brought into operation, and if such legislation has not been brought into operation, when it is expected to be brought into operation, and the further processes that need to be completed in order for such legislation to be brought into operation. Upon furnishing of such a report, or in the absence of such a report, any of the parties may apply, insofar as it is necessary, for supplementary relief to become operative upon the expiry of the 36-month suspension period. Such application shall be brought not later than 4 months before the expiry of the suspension period, and its further conduct shall be regulated by directions issued by the Chief Justice. 8, the Minister must pay the applicant's costs in this court, including the costs of 2 counsel where so employed. I hand down the judgment.
As the court pleases.
As the court pleases.
Thank you. My brother Matopo is going to proceed with his matter, and maybe whilst this matter is being called, it would be opportune for you to excuse yourself if you wish to. But if you wish to remain, you may. Thank you.
I call the matter Jacob Linguistic Translation and another, and President of the Republic of South Africa and others for judgment.
Good morning, Justices.